In front of you, you should have revised verdict sheets that conform to the charge conference that we just completed. You should have a revised set of the instructions involving the offense committed against Sylvester Taylor. I'm making the final changes to the set of instructions for the offense committed against Anglia Taylor, but they are identical except truncated. So the language we discussed is all now in front of you. Yes?
I don't see the verdict sheets.
Oh,
Okay.
I'm sorry. That's we need both.
Any other comments, corrections, or suggestions with respect to the jury instructions or the verdict sheets?
Nothing as to the instructions. We'll wait to see the verdict sheet.
All right. Okay, well then we'll just wait a few minutes till those are... review the verdict sheets. Any objection at this stage? That you...
Not having a chance to look at it quickly, no.
All right, and I'll ask again before we send them back to the jury room, and I'll be proofreading both the jury instructions and the verdict forms before we submit them to the jury, but we just wanted to make sure we got all the corrections in that we talked about during the charge conference. All right, anything else that we need to take up before we bring the jurors out? All right, if not, let's go ahead and bring jurors, please. Mr. Lively, do you have anything you want to start with?
Yeah, Your Honor, I think I've plugged it into the right port. Are you seeing anything on your screen?
All I have is the judicial seal, so I don't have...
Function F7. Function F7.
You tell Tony just wait a second. Technology study. Okay. All right, I can get it from there.
And Judge, can I just check real quick to see if this clicker works?
Okay, hold on, let me, okay, there you go. All right, I think you can, we can tell Tony. Whenever you're ready, tell Tony we're ready to go. All right, welcome back, ladies and gentlemen. Thank you all for accommodating our schedule. I think we're now ready to proceed with the closing arguments in the second phase. In the second phase, we're going to hear two closing arguments, in total two closing arguments. The state will have the opportunity to argue first, and then the defense will have the opportunity to argue. The state has elected to divide their arguments into two parts. We're going to hear first from Mr. Lively, then we'll hear from Mr. Waller. And the defense has also elected to divide their arguments into two parts. We'll hear first from Ms. Hamburger, and then we'll hear from Mr. Brown. So, Mr. Lively.
Thank you, Your Honor, counsel. Ladies and gentlemen, there was snow on the ground the day we met, and there were thunderstorms last night. This is our third calendar month of considering this case, the state versus Nathan Holden. And it's taken a long time, and that's because it's that important a case to the state. We have committed, Mr. Waller and I, to being here for the last 2 months to pick you people because you were uniquely qualified to deliberate in this case and to make the hard decisions that we need you to do. And I remember a few of you spoke with me, more of you spoke with Mr. Waller, but I know, and I hope you remember back then that he said, what we're doing now is an academic exercise, talking about voir dire in January. But at some point it's going to get really real if you're selected to be on this jury, and that's where we are today. This is the most important decision that a juror can make in the state of North Carolina in the most important type of case. And we need you to do what you've already done, and that's to deliberate fairly, to consider all of the evidence, and then apply it to the law. And we know you'll do that. You already have. But I want to talk to you because maybe your memory's grown a little foggy of the process that we were talking to you about back in January with all the evidence you've heard and the deliberations you had to do in Part 1. So here's how we're going to split it up. I'm going to go first, and I'm going to talk about mitigation, and Mr. Waller's going to talk to you about the aggravating circumstances. This is the state versus Nathan Holden. Now, again, you remember that four-part process that we talked to you about and that you would need to engage in if we got to this stage. And the first thing that you're going to need to do is decide unanimously, beyond a reasonable doubt, that one or more aggravating circumstances exist. Mr. Waller will explain the aggravating circumstance to you. And then to consider the mitigating circumstances that will be presented to you and find if one or more of those exist. And I believe the judge is going to submit about 38 of those to you. And then you're going to do what Mr. Waller called the weighing plus one. That is, you're going to take the scales of justice that we talked about, and you're going to place the aggravator in one, and you're going to place the mitigators in the other if you find them. And you're going to see which weighs more. We talked about a bowling ball versus feathers, that there will likely be a lot more mitigating circumstances than aggravating circumstances. And so I'll talk to you about that a little bit further later. And then when you find the aggravating circumstance outweighs the mitigating circumstances, that they're sufficiently substantial to call for the imposition of the death penalty when considered along with any mitigating circumstances. Again, that's the process. That's what the judge is going to instruct you on and what we're going to ask you to do. And mitigating circumstances, he'll tell you, are a fact or a group of facts which do not constitute a justification or excuse for a killing or reduce it to a lesser degree of crime than first-degree murder, which may be considered as extenuating or reducing the moral culpability of the killing, or making it less deserving of the extreme punishment than other first-degree murders. So let's just be clear. Nothing that you hear, that you've heard in the sentencing phase changes the fact that the defendant is guilty of 2 counts of first-degree murder. He is a convicted murderer 2 times over based on your deliberations. But you heard some evidence that the defense would have you consider in sparing his life, and that's what they're going to be asking you to do today. Well, I want to talk to you, because there aren't specific instructions for how to weigh all of the factors, the aggravating factor and the mitigating factor. But I would like to suggest some things to you and talk about some of the particular mitigators that you're going to be asked to consider. And of course, you've already done this once. Y'all are experienced jurors. You know how to do this. You know how to deliberate. But you have to decide the credibility of each witness. You're the sole judges of their credibility, and you have to decide whether to believe all, none, or part of what any of them say. And there are certain tests of truthfulness that you use, and that's their opportunity to see, hear, know, remember the facts or occurrences, their manner and appearance, any interest, bias, or prejudice they might have, their apparent understanding and fairness, and whether their testimony is consistent with the other believable evidence in the case. You also decide if certain evidence is believable, what the importance of that evidence is in light of all the other believable evidence in the case. So, I want to talk about post-traumatic stress disorder, or the mental and emotional disturbances that the defense contends that the defendant was suffering from on the night of the crime. And again, it's not a defense to first-degree murder. You've already convicted him of that. But there are several mitigating circumstances you're going to be asked to consider. One was the capital felony committed while the defendant was under the influence of a mental or emotional disturbance. The capacity of the defendant to appreciate the criminality of his conduct or conform his conduct to the requirements of the law. Also, you'll be asked to decide whether or not he suffers from PTSD and could have benefited from mental health treatment. Again, not to excuse or justify his crime. He's already guilty, but simply to just to spare his life and enter a sentence of life in prison. Now, you heard from Dr. Blackshear, and you heard several things. And again, we're talking about credibility of witnesses, manner, appearance, bias, fairness, things like that. So in judging their credibility, these things are fair game. One, that he was hired by the defense. He was called by Mr. Brown and met with the defendant, I think on 6 occasions. The first time he met with him was over a year after the crime, and met with him several times. Got the defendant's version of events, reviewed some records that the state may have provided to the defense in discovery, and also other documents that the defense provided to him. He was paid for his work at $210 an hour. He doesn't have a final number, but we know he was here on the stand for about 4 hours yesterday. Claims he spent 15 hours with the defendant, presumably reading all of those records and reports. Was paid, thousands of dollars for his testimony. And he was hired to evaluate the defendant for any psychological issues that may be relevant. That was what he was sort of charged to do with the defendant, Mr. Holden. And, you can consider all of that in determining whether to believe all, none, or part of what he said. Now, Dr. Blackshear gave his opinion that the defendant had PTSD. And he attributed it to several factors: a DV home, dysfunction in the home, lack of adaptive functioning, and the crack addiction of his mother, the family breaking up, and community violence, which he referred to as a robbery and a beating. But what is PTSD? So PTSD is the development of characteristic symptoms following exposure to one or more traumatic events. And it goes A through H. There are certain criteria that have to be met, just of symptoms that are triggered by some sort of traumatic event. And I want to talk to you about how Dr. Blackshear went through that and coming to his finding. So the first is exposure to actual or threatened death, serious injury, or sexual violence in one of the following ways. And I think Dr. Blackshear said that the defendant directly experienced being pistol whipped in a robbery, that he witnessed in person the domestic violence in his home. So those were found by the doctor. Next is the presence of one or more of the following intrusion symptoms associated with the traumatic event, beginning after the traumatic event occurred. And so he found 2 things here. There are 5 that he could have found. One is recurrent, involuntary, and intrusive, distressing memories of the traumatic event. Now, the thing about PTSD and his evaluation is, he looked at a lot of records, and nothing in the records indicated that number 1 existed. But it was reported to him by the defendant. I call that self-reporting. The defendant said, I had recurrent, involuntary, and intrusive, distressing memories of a traumatic event. And then a dissociative reaction or a flashback, or, that's the kind of situation where you feel like you've left your body, you're not in control of your own body. And again, that was a self-report from the defendant. One time, April 9th, 2014. Based on the trauma that he observed growing up as a child, and then after being hit in the head with a pistol in 2009, 8 years later, he has his single dissociative episode when he murders Anglia Taylor, Sylvester Taylor, and attempts to murder LaTanya Adams. And again, you have to have the presence of one of those. Dr. Blackshear found 2, both through the self-reporting of the defendant. And you can continue to consider the purpose for which Dr. Blackshear is there. C, persistent avoidance of stimuli associated with the traumatic events, beginning after the traumatic event occurred, as evidenced by one or both of the following. Dr. Blackshear, when he originally on direct went through his findings of PTSD, skipped C originally. We had to go back and walk through it, and I had to ask him specifically what he found. And essentially, this is avoidance. So someone who is suffering from PTSD actively avoids or tries to avoid external reminders that arouse distressing memories, thoughts, or feelings about or closely associated with the traumatic event, or to avoid the distressing memories, thoughts, or feelings about the traumatic events. And I don't see any evidence of avoidance here of anything. You know, if Nathaniel Carroll, his father, had caused him to have post-traumatic stress disorder, wouldn't he avoid him? But they had a relationship, apparently a good relationship in their adulthood. If Sylvester Taylor was threatening to him, would he avoid him? No, he went there that night with a gun. D, negative alterations in cognition and mood associated with the traumatic events beginning after the traumatic events occurred, as evidenced by two or more of the following. And you'll see that one is not appropriate. There's no inability to remember an important aspect of the traumatic event because he reported the traumatic events to Dr. Blackshear. He reported them himself. No persistent negative emotional state, marked diminish interest in activities, feelings of detachment, or persistent inability to experience positive emotions. The two things that Dr. Blackshear found, and which he would need to find to give you his expert opinion, were persistent and exaggerated negative beliefs or expectations about Sylvester or about whoever caused the triggering event, and persistent distorted cognitions about the cause or consequence of the traumatic events that leads him to blame others. Now, again, Dr. Blackshear made his own assessment of that. He said that the defendant's beliefs about Sylvester, about the crime, about the cause of the crime were exaggerated. And that may be true to Dr. Blackshear, but what if the defendant believed them? I mean, what if they just were true to him? I don't know that they have shown that there's a negative alteration in cognition, but where the defendant wasn't able to clearly give it to him, Dr. Blackshear, I think you could find supplied it for him. E, marked alterations in arousal and reactivity associated with the traumatic event, beginning after the traumatic event occurred. Need two or more of the following. Well, let's see. I don't think they found 4, 5, or 6, not an exaggerated startle response, problems with concentration or sleep disturbance. Irritable behavior and angry outbursts were only towards Sylvester, LaTanya, and JT in the evidence. And none of those people seem associated with the reported trauma from his youth or from the home invasion robbery that he reported. And then reckless or self-destructive behavior. Dr. Blackshear said that his drug and alcohol use and the sale of narcotics were all self-destructive. But the defendant, didn't report that himself. Dr. Blackshear found that it could be in his opinion, but there's no other evidence that he was trying to self-destruct or do any other thing than to drink socially, smoke socially, and sell narcotics to, just to bring in money. So, again, consider his credibility as he's going through his assessment here. The duration of the disturbance is more than 1 month, and it says in the DSM-5 that 50% of these cases of post-traumatic stress disorder resolve within 3 months, and maybe some last as long as 12 months, and then it says some last as long as 50 years. So it's a broad spectrum. But remember, the traumatic event that's supposed to be triggering all of this is not the separation or the breakup, or what happened on January 26th between Jeremy and Sylvester. The traumatic event was May of 2009, where the defendant reported that people came into his house and pistol whipped him. And before that, the traumatic events, I guess, were sort of throughout his childhood between Nathaniel and Goldie. So, again, no dissociative state, none of the symptoms that you would expect for a PTSD diagnosis until some 8 years after. I mean, he talked about delayed expression, but again, I think in using your reason and common sense, you should find that he did not suffer from post-traumatic stress disorder. That the disturbance caused clinically significant distress or impairment in social, occupational, and important areas of functioning. Well, through the defense's evidence and the testimony of family members, while he was sad that his wife had left him, he continued to maintain his bonds with his friends and family. He continued to go to work. He continued to apparently do some renovations to the house he moved into on Holden Acres. And so I would submit to you there's no evidence of that. And then that the disturbance is not attributable to the physiological effects of a substance. And I don't know that the doctor even kind of went to that. The defendant told him that he drank 2 or 3 six-packs on the day of the murders, but I don't know how that was accounted for. The bottom line is what Dr. Blackshear came to was an opinion that the defendant had post-traumatic stress disorder. Now let's talk more about credibility. I'll go to number 2 first. Dr. Blackshear used a theory that he called complex trauma that's not discussed in the DSM-5. This is the DSM-5. He called it the diagnostic Bible for forensic psychologists. And there has to be a traumatic event. And so, the traumatic event could be the home invasion robbery or the domestic violence he witnessed in the home. But nowhere listed in that is there anything called complex trauma. Now, he said it might be in the next edition, but it's not in this edition. And it might not be in the next edition. We don't know. So right now, for today, he has sort of gone out of bounds, away from got beat up in this robbery home invasion. And what do all of them say? He's never angry, never heard him confused or not know where he was, to dissociate, to hide from people or avoid people or situations. The people that know him best find none of it. The doctor that was hired finds it. The defendant was alert and oriented to provide Dr. Blackshear with information. Of course he was. Dr. Blackshear told him why he was there. This is the defendant's opportunity. Here you go. What do you need? This is how bad my life is. This is why I'm not responsible and why I should not be sentenced to death. And again, number 7, I say none of the symptoms are testified to by the family. Now, I'm not picking on Dr. Blackshear. I mean, he, to an extent, has to deal with what he's been given. And one of the things he's been given is a statement by the defendant, and he didn't know at the time because he didn't get do any investigation or, wasn't able to talk to LaTanya perhaps. He got one side of the story. And he talked about the defendant's side of the story yesterday. What the defendant told him about what happened that night. And a couple of the things he said, was that he got there and his father-in-law just came out running at him and he just started shooting. And that then he thought that Anglia was Mr. Taylor. Well, I mean, it just doesn't make sense with the evidence you've already found and the decision you've made. There's no evidence that there was any sort of struggle out front. There are no shell casings there. And, if you believe that he went into the house, saw Sylvester Taylor there and shot him 1, 2, 3, 4 times in the house and outside of the house, then why does he mistake Anglia for him as well? Is he seeing double? No. It doesn't make sense because he's not telling him the truth. And he then says that he went to push LaTanya and that the gun went off accidentally. He says it went off accidentally, presumably once. And have found that the gun went off 3 times, and it didn't go off. It was pulled. Dr. Blackshear didn't have the benefit of the testimony of Elizabeth Wilson from SBI. He didn't have the benefit of the CCBI reports. He didn't have the benefit of the pictures to look at. But again, it is not credible. It flies in the case of the credible, believable, physical evidence that this was an accident and he didn't even realize she was shot until she fell on the bed. He shot her once in the face and he shot her once in the chest after he pistol whipped her. So again, the defendant, seeing the good doctor there to help, supplies him with a story that he hopes will buy him out of here. But he also says to the doctor, if I'd planned to do something, my mother-in-law wouldn't have been killed. He doesn't say anything about LaTanya or Sylvester. What he also did, though, is he told the doctor that he didn't have any history of mental health treatment and that he denied feeling depressed at the time of the shooting. He said he felt like he was moving on with his life. Well, that part was true. Look, it's not PTSD. And remember, again, it's not a justification or excuse to or defense to first-degree murder. You've already convicted him of that. The interesting thing about post-traumatic stress disorder, though, and the doctor's finding of it being related to childhood trauma is it makes relevant all of those upsetting things that you heard about the defendant's childhood, so that you can then hear from his mother and his father and his brothers and sisters and hear about the adversity he went through. And it's upsetting to hear, but I'll say a couple of things about it. First of all, it appears that for most of his life, he had overcome it. That he was not on a course that was out of his control because his mother was an alcoholic, or because there was domestic violence, or because there were divorce or custody issues, or he had to go stay with a different aunt. One of the mitigating factors that the state concedes exists is he graduated from high school. And you heard some of the opportunities he had and good things he did with his family. So these things didn't break him, didn't make what happened on April 9th inevitable or beyond his control or his ability to decide. They are what they are. He's a person, like most people, who's had adversity. And again, most people are able to overcome the adversity, move on, do good things with their lives. And it personalizes him, certainly. But again, most people move on with their lives. Maybe they get divorced later. Maybe they have to have mental health treatment. We all deal with things differently. But it doesn't have to end in a courtroom like this. And there are witnesses that were called by the defense that saw the same alcoholism, that saw the same violence, that saw the same instability. And it affected them too, but they're not here. Mitigating factors can be about anything, related to the crime or not related to the crime, about the defendant. But again, what sort of weight do you need to give them? It's a silly example that we gave you at the beginning, but I think it's truly accurate. Look, there are 39 mitigating factors for you to consider, and there's one aggravating factor. And you could find he's got no significant prior criminal history. You could. One or more of you could find it. You could find he loves his children. That's going to be submitted to you. I think one of the family members was talking about Goldie and Big Nate when they were coming along, and said she stayed with him because she said she loved him. And I think she might have said something like, that ain't love, but that's a twisted view of love. So I hope when you're looking at that mitigating factor that certainly the defendant has said that, will continue to say that, and perhaps on some level does. But again, how do we love our children? It's the example we set for them. It's the way we treat them. It's the way we provide for them. In terms of mitigation, based on his choices on April 9th, I would ask you not just to check that without considering it. Nathan Holden saw his father beating his mother. His mother suffered from alcoholism. His father was unfaithful to his mother. His mother became a crack cocaine addict when he was in high school. Again, sad things. Sad things that don't bring back the Taylors. And don't excuse his actions. So it's up to you to decide what sort of mitigating value they have. That he was beaten by multiple men during a home invasion robbery. You heard Dr. Blackshear say that played no part in his in any sort of traumatic brain injury. There wasn't sort of an organic brain functioning problem he was having that affected his executive functioning or prevented him from thinking clearly on April 9th of 2014. So, Mr. Waller is going to come talk to you about the violent course of conduct that the defendant engaged in on that evening. And we want you to go back there, and we ask that you finish the job and you consider all of these things in due course, that you find the aggravating factor first, that you go through these 39 mitigating factors, and then that you weigh them. But all the things that have happened in the past are past. And none of them have the effect of the violent course of conduct that the defendant, the convicted murderer, went on that evening. What he did will have a greater effect on the lives of his children and their children, and LaTanya and Sylvester and Jamar, and on his family, and on his family's ability to see their grandchildren or their nephews or their nieces. That violent course of conduct is a stone that's sinking this family. It is more heavy, weighty, whatever you want to call it, than all 39 of these things that the defendant saw, did in his life up to that moment. This is the most important thing the defendant ever did in his life. And it is much more significant than the 39 things that they're going to ask you to consider, and it didn't have to happen. This is the egregious case. This is the case that calls for the imposition of the death penalty. I hope that you will consider the mitigating factors in the manner in which I presented them to you, and I hope you'll listen to Mr. Wilder as he talks to you about the violent course of conduct, follow the law, and return the verdict that the law requires. Thank you.
Thank you, Mr. Wilder. Mr. Wilder.
Maybe have just a few minutes for me. May it please the court, Mr. Brown, Ms. Hamburg. Ladies and gentlemen, first of all, thank you for bringing us this far. Thank you for the work that you have already done, doing your duty as a Wake County citizen in this case. But as we've talked about from when we began jury selection, this is a long process, a process that you're about to come to the end of. But we're not there yet. And I use that word process because that's a word that you heard a lot about in jury selection. It's a word you've heard a lot about from Mr. Lively, and it's a word that you will hear about from me. Following the law, doing your duty as Wake County citizens. My job at this point is to talk to you a little bit about the aggravating circumstance that exists in this case. And I have aggravating circumstances there, but it is just one aggravating circumstance that we're going to offer to you in this case that Judge Ridgway is going to explain to you. But as Mr. Lively said, the fact that there's just one is not in and of itself the deciding factor in your deliberations. Because after I argue this to you, I hope that you will find that one circumstance that you will hear about indeed makes this the egregious case. Aggravating circumstances are a group of facts, or facts or a fact in this case that makes the imposition of the death penalty the more appropriate punishment in this case. You're going to hear about aggravating circumstance E11. But that, and when we went through jury selection, I told you there were 11 aggravating factors that you could consider by statute, and this is E11. Murder part of a course of violent conduct. The murder of Anglia and/or Sylvester Taylor was part of a course of conduct which the defendant engaged, and that course of conduct included the commission by the defendant of other crimes of violence against another person or persons. The first thing I want you to notice about that quote is the and/or Anglia and/or Sylvester Taylor. When Judge Ridgway instructs you on the law, in this case, you will be able to decide whether the death penalty is appropriate for Anglia's case, for Sylvester's case, or for both of their cases. It can be one or both. And it's about things that happen throughout that night. Things that happened the moment that defendant or the defendant walked in the door at Lake Glad Road at around 10 o'clock and culminated in his arrest in that field at Holden Acres at around 3 o'clock in the morning. That whole 6-8 hour period is legally for your consideration. From the moment he walked in the door to the moment that those handcuffs were put on him in that field. That violence that he showed to Anglia, Sylvester, LaTanya, the kids, the law enforcement officers, all that night. All for your consideration. And I say when he walked through the door. Ladies and gentlemen, there is absolutely no evidence in this case that violence took place outside of that house in the front. The scenario that Mr. Lively just read to you and the scenario you've heard before, think about it for a moment. If the defendant and Sylvester got into an altercation out in front of that house and Sylvester was shot out in front of that house, that would mean that Sylvester ran back in that house where his wife and daughter and 3 grandchildren were, bringing the defendant with him, without a speck of blood on the front porch there, without any damage to the door. Sylvester would have had to run back in that house, bringing the defendant with him, then other shots fired in the house, and then run through the house to being killed outside. That scenario doesn't make sense, and there's no evidence to support that scenario. And you are to decide this case based on the evidence presented to you. So what did happen in this case? Where did the violence begin, and how did it go through that house? That's what I intend to show you here in this slideshow. I'm going to show you some photographs you probably haven't seen in a while. And I show them to you to remind you of what happened, but to also explain the pattern of violence that was shown in that house to those victims that night. Violence at the front door. The defendant walked in that house with this gun that he had brought with him. And he takes that first shot. And how do we know that's where a shot took place? Because of that shell casing that's shown by CCBI marker number 13. And let me say one thing about shell casings before we get too far into this. A shell casing, it is ejected from this gun, comes out this side right here. It's ejected, which means it's thrown out the side, and it hits the ground, and it can roll, and it can move. So I'm not saying these are the exact places where the defendant was when these shots were taken, but they're pretty daggone close. So he comes in the door, and he takes that first shot. Excuse me as I bring things out here. And we start with number 13 there, a shell casing. Based on the evidence you've heard from LaTanya and JT, I would argue to you that was the first shell casing that hit Sylvester. Pulling the trigger and shooting Sylvester. Sylvester then runs out. And then you go to the next individual, or the next place. Violence in Anglia's bedroom. State's exhibit number 202 is the shell casing that you see there in that slide. You'll see CBI number 14. So at this point you've got 2 shell casings. I'm going to ask you, I'm not very good at math. I'm a lawyer for a reason because I don't do math, but I'm going to ask that you do some math for me here in a minute. So keep up with me to the best you can in terms of the number of shots that we're talking about here. So he goes in Anglia's bedroom, and there's a shot in there. And Anglia is killed. We owe the Taylor family an apology. We owe you an apology. Anglia Taylor is the forgotten lady in this case. We spent days last week talking about Sylvester and January 1st, and we've spent days talking about Sylvester and January 26th, and we spent days talking about the defendant's relationship with Sylvester. We forgot about Anglia. There is absolutely no evidence that this woman did anything to that defendant. I think at most you've heard that the defendant was upset with her at some point because he wasn't scolding LaTanya about any extramarital affairs she may have had. That's it. If you'll remember from jury selection, we talked about felony murder. And I gave you the very basic example of someone walking into a convenience store to rob that convenience store, and during the course of the robbery, the clerk was killed or an innocent bystander. Ladies and gentlemen, Anglia is the innocent bystander. She just happened to be there. And this defendant took this gun and aimed it at her chest, pulled the trigger, requiring 7 pounds of pressure, and shot her in the heart. She had just gotten back from church. You can see her pastor robe there on the door. You can see that she was still clothed, but in the midst of undressing from church. And you've also heard that the defendant stopped by that church with JT prior to coming over here. Ladies and gentlemen, ask yourself, what would have happened if LaTanya had been at church? What if she was there? Anglia was the only, or was an innocent bystander here. Could have been different. Don't forget about Anglia. She deserves to be heard as well. The violence continued outside. You know that because of the spot of blood there on the porch. I would argue too that after that first shot hit Sylvester, he took off running out the back door. As you'll see from a photographs here in a few moments. He was soaked with blood. He was bleeding at that point, and that's a blood trail from Sylvester running outside that door. Violence to Sylvester. 4 times. Not once, not twice, not 3 times, but 4 times this man was shot. Defenseless. Left to die like that in his backyard. 4 times this trigger was pulled and aimed at Sylvester. In looking at the evidence, you will recall that the CCBI agents went back out to Lake Glad on April 14th. And they found another shell casing right there near Sylvester's body. Shot at close range. You can see, it's hard to tell from this photograph, I apologize, but this is State's Exhibit 70, the shell casing I just put on the bar in front of the judge, and it shows you the relation. Here's Sylvester in the field, and that's the basketball goal that we saw earlier. So you see where Sylvester's body was and where that shell casing was discharged. When the medical examiner talked to you about soot and stippling, that required a shot at close range. That shell casing was found within feet of Sylvester's body. So at this point, we have 1 shell casing for Anglia, 2 that I will associate with Sylvester, Sylvester's autopsy. I put thumbtacks in here for the entrance wounds and exit wounds. I'm sorry, they're very similar colors, but 1 light green, 2 is the teal, 3 a darker green, and 4 is the yellow. So we know by the evidence that Sylvester was shot 4 times. So 4 different bullets. And then we have Anglia, who was shot once. It was a through and through wound through her hand into her heart. So we're at this point up to 4 shots for Sylvester, 1 for Anglia, that's 5. Then we go to LaTanya. Violence to LaTanya. The blood on the walls, the damage to the walls where she took that beating. The gunshots. Markers 15, 16, and 17. 16 is here in the foreground, 15 there in the middle of the screen, and if you'll recall, 17 was the projectile that was found inside the closet. Marker 15 is another shell casing. There's one for LaTanya. As you recall, marker 17 was a projectile. So it, for the purposes of our math here, we'll just put it with this shell casing because obviously the projectile has to come from a shell casing. But it shows the pattern of violence. Marker 16 was the actual live round that jammed in the gun. When you talk about an attempted murder on LaTanya, that little crease right there is what could have saved LaTanya's life. That little, almost microscopic indentation is what saved LaTanya's life. So we add that to our count. Marker 69. Again, when they came back the next day, on April 14th, another shell casing was found for LaTanya in that bedroom. So at this point, you have 1 shot for Anglia, 4 shots for Sylvester, and 3 shots for LaTanya. Again, my math can be kind of wary, but that's, by my count, 8 shots. If you remember the testimony from the agent, she said this gun holds 8 shots. Violence to the kids. They weren't physically hurt. They weren't beat. They weren't shot. But ladies and gentlemen, they were a matter of inches from where their mother was beat and shot. You talk about violence to someone. Violence that someone will have to live with for the rest of their lives. That's violence. You want to talk about loving your kids, loving your family, wanting to be with your kids, wanting to be with your family? Inches away. That's not love. That's not wanting to be with someone. That is ruining the rest of their lives by violence. You heard Dr. Blackshear talk about all of this that we just walked through, that the defendant was disassociated, that he was somewhere else. This wasn't him. That Nate didn't become Nate again until that moment in the woods when he was arrested. That's when the true Nate came back. That this was all, he was just in a cloud. Well, think about what he did after he killed those 2 people and beat LaTanya. He had the wherewithal to put his wallet on the dresser there, marked by number 20. He had the wherewithal to call 911. He had the wherewithal to take his truck to Carl Staten's house and drop it off. He had the wherewithal to call his buddy Douglas Carroll to come pick him up and take him back to his home place, Holden Acres. What kind of fog is that? What kind of disassociation with reality is that? That's called planning to get out of there. That's being in full control of what you're doing after murdering 2 people and assaulting someone else. So he goes back to Holden Acres. That's hard to see. Forgot to. He goes back to Holden Acres. And this is kind of far, and here's his house, and this red thumbtack is where he's eventually located. You heard Deputy Canoose say that their track led them through the woods I think he said 20 yards away from where the defendant is eventually apprehended. They come through the woods and exit around the power lines and then come back up the wood, along the wood line. You heard yesterday, I think, that the defendant was praying when the officers came upon him. Well, that's a very interesting place to stop and pray. I would argue to you, as Deputy Manville said, that's a place where you stop to ambush someone. The people that you've heard coming through the woods will not be suspecting you around that corner. And I know that picture on the left of the screen is fairly blurry, but I argue to you that it shows a good depiction of that curve. That they walked around a blind curve. And when they got around that blind curve, the defendant raised his right hand and he fired as they walked around that curve in the dark. Violence. A continuing pattern of violence. Again, it's kind of hard to see if you need the photographs, they're in evidence, but just to show you the relation of the distance, if you see this photograph here on the left, I know it's hard not to totally visualize this not being out there, but you remember all the deputies talked about they came out of the woods underneath the power lines. Well, there's your power line in the background, and it shows the direction they came across the wood line. And I put that one up there, that photograph up, to give you a little sense of direction. I put this photograph up here to give you a sense of space, of how close it was. That's the area, this clutter, where the deputies fired at the defendant. Back there, that little yellow flag is where Deputy Simmons was with the dog. This area right here, if you recall from Agent Foran's testimony in the first phase, is where the defendant was found. I think someone said 20 feet. I'm not a great judge of distance as well, but you can look at that photograph and you can tell it was close. You can tell someone firing from that distance has one intent: to inflict violence upon those people, upon those officers. So let's get back to our map. You had Agent Foran testify that she found 2 shell casings there at the scene at Holden Acres. State's exhibits number 153 and 152. Two more shell casings. Eight fired at Lake Glad. 2 fired at the deputies in the field. When the gun was collected, the magazine still in it. Three in the magazine and 1 cocked in the chamber. By my, again, rough math, that's 6. Y'all are smarter than me. You know where this is going. A box of bullets found in the defendant's bedroom at Holden Acres. He had to go reload. He shot Anglia, he shot Sylvester, he shot LaTanya, he beat her with the gun, he drops his car off, he gets his buddy to take him to his house to do what? Reload. That's violence. That's having one thing in mind, violence. Course of conduct, a violent course of conduct that night. To go and reload. He wasn't done. He missed. The other one jams in the gun. That third shot thankfully jams too. But he reloads. The process. The process that we talked about, some of you from January 11th, I guess. Step one, or issue one, is that you're asked to find if there is an aggravating circumstance in this case. And I hope, ladies and gentlemen, based on that demonstration, those slides, that you will absolutely, beyond a reasonable doubt, find yes, that aggravating circumstance exists. So you're going to get an issues and recommendation sheet just like this one. And in step one, issue one, the first question is, do you unanimously find from the evidence beyond a reasonable doubt the existence of the following aggravating circumstances? Answer yes there. Write it in. That aggravating circumstance is a violent course of conduct. Yes, based on the evidence that you've just seen before you. Issue two is mitigation. Do you find from the evidence the existence of one or more mitigating circumstances? Yes, you're going to find a mitigating circumstance, okay? I put yes in the same font as I did for issue one. You're going to find a mitigating circumstance. Yes. But then the question becomes at issue three, the weight. And as we talked about, this is where the balancing test comes into play, where you have to use your reason and common sense in applying the weight to this one aggravating circumstance and these 39 mitigating circumstances. And I'm not saying you're going to find 39, but you're going to find some, and so you're going to weigh them. You have to use your reason and common sense. The law does not apply a value to each one of these. It's for you to decide. This is the area in the weighing process where the law reads kind of funny. Do you find unanimously that the mitigating factors are insufficient to outweigh the aggravating factors? And the way that we phrase that is, do the aggravating factors outweigh the mitigating factors? No matter how you phrase that question, issue three, we'd ask that you find yes. Issue four, and again, at issue two, you're going to write yes. At issue three, after going through those mitigating factors, again, write yes. And then you come to that fourth and final step. Are the aggravating factors, in light of the mitigating factors, sufficiently substantial to call for the imposition of the death penalty? I think Judge Ridgway will tell you that the death penalty is justified and appropriate for this case. I ask that you answer yes there, and then to do that final thing that we talked about and Mr. Lively mentioned, you go from this academic exercise to the final process of writing the word death, and someone signs their name. So how do you do it? How do you go through it? Look, thought about coming up here and playing you the video of the kids in the car. Of JT and Amber and Nautica sitting in the back of Deputy Evans' patrol car and showing that to you again. Well, one, I hope that you haven't forgotten that video. I don't know how you could, but I hope you haven't forgotten it. But there's another reason not to show it to you, and it's because of the respect for this process. This is the most serious thing you will ever be asked to do. And I could come up here and play that video and hope that it gets you all fired up and inflames you, but that's not what this process is about. It's about respect. It's about a solemn oath that you took, and it'd be hypocritical of me, because when we talked in jury selection, I said, we understand that you're going to come in here with emotions, and this is a terrible situation. I hope it's made you angry. I hope it's made you sad. But at the end of the day, it would be wrong for me to ask you to sentence this man to death based on emotion. The process, the law, requires you to go through this step by step and decide this case based on the evidence that you've heard. It may have been corny and cliche, but I asked each of you in talking about your views about the death penalty to go somewhere where you're comfortable. And I think for the majority of you, I used a restaurant. Some of you may be thinking, why would we be talking about the death penalty at a restaurant? But the point of that conversation was to ask that you take yourself out of this situation. And using your reason and common sense, tell us what you thought about the death penalty. Well, we're there again. And some, I wish we could have another conversation, but some of the issues you may be thinking about in this are, domestic violence. Well, this is a domestic violence case. This is a case about, a family not getting along, and Nate's or defendant's hatred for Sylvester and whatnot. It's not about that. And the law not only protects the defendant, but it protects the victims as well. Well, why is this case any different than if Nate had walked in there to a house where he didn't know anybody? It's no different. Just because he knows these people doesn't excuse them. It doesn't bring them back. The law enforcement officers, he didn't know them, and he shot at them. So just the fact that these people know each other is not an excuse. It doesn't mitigate this. Then you've heard a lot about PTSD, and Mr. Lively covered that. But bad things happen to people, ladies and gentlemen. People have heartbreak. People break up. People have bad days. People get divorced. Most of the people in this courtroom, you've heard, have been through some divorce. People have had bad childhoods. Sure, he had a bad childhood. But other people have had bad childhoods. This PTSD diagnosis is not a license to just kill. It's not a license to just go out there and shoot 2 people, 3 people that made you mad. You talk about a bad childhood, I can name 3 people that have had a much worse childhood than this defendant. Amber, Nautica, and JT. And you've seen JT. And you've seen those girls in the back of the car. Who was Nate Holden? Nate Holden is a person that reacts in a violent and threatening manner when someone tries to take something from him that he wants. You heard from Mr. Aiken about him threatening guards in jail, saying, I'll take care of you when I get out of here, or someone's going to hurt that chick. And why? Because they were taking his playing cards, and they were moving him to somewhere he didn't want to be. He shot at the police officers because they were there to take his freedom that he wanted. And he shot at them because it was something he wanted, and they wanted to take his freedom away. He shot and beat LaTanya because she had taken the kids and ended their marriage, something that he didn't want to happen. Shot and killed Anglia by shooting her one time in the heart because he thought that she was standing in the way of something he wanted. He shot and killed Sylvester, shooting him 4 times because he was standing in the way of something he wanted. It's time, ladies and gentlemen, for you to decide this case. It's in your hands now. The defendant said they got what they deserved. But it's time for you to put aside your personal views, whether you like me and Mr. Lively or don't like us, or Mr. Brown and Miss Hamburger. It's time to set that aside. It's time to set aside your personal opinions on the death penalty and decide this case based on the law and the evidence. And ladies and gentlemen, if you're at that restaurant and you hear the description of someone that shot at 4 police officers, beat a woman and shot her in the chest and face, shot a woman in the heart, and shot a man 4 times laying in his field, you have to ask yourself at this point, what does that person deserve? To live or die? I would argue too that the law supports a death sentence in this case. That's what I'm asking you to do. It's what I am asking you to do. But it's not my decision anymore. It's not Mr. Lively's decision. It's your decision. But do it based on the process. It's not a knee-jerk reaction. You go back there and you walk yourself through it. Give him what he deserves. Thank you.
Waller. We'll take a 10-minute recess until 10 minutes past 3, and then we'll resume with the arguments for the defense. Members of the jury, if you'll return to the deliberation room at 10 past 3. We'll be at recess until 10 past 3. As I recall, neither of you were using the screen, or...
That's correct.
All right, I'll go ahead and put them up.